Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good morning, Tampa. Welcome to another Ask the Expert show, where for the last 16 years, we've brought you the top experts in the field of legal, health, financial, and home improvement. I'm not going to tell everybody what the temperature is here in beautiful South Florida. And I really feel my heart goes out to the people on the East Coast, what they're going through. But stay hunkered in and just, hey, for the next 25 minutes, we're going to be talking about estate planning. We were so blessed to get one of the top estate planning attorneys in the state of Florida. Let me introduce you to our long-standing expert, my friend, attorney Debbie Baker. Good morning, Debbie.
Hey, Steve. As long as you didn't call me old, I'm good. Yes.
No.
Long-standing. Long-standing is good. You know, we exchanged a couple of emails over the weekend, and then I looked at the title of what you titled today about probate. And if you don't mind, I think I'd like to talk about probate a little bit. We talk about estate planning, and we talk about how important it is and essential it is, and it is. And some of you listening or watching may have experienced probate or know somebody who has, and often people have no idea what it is, which is very reasonable. Why would you? But probate is a legal process that's required when somebody dies and they own anything only in their own name, where for some strange reason they have not named a beneficiary to get it, or they haven't put it in an estate planning vehicle such as a trust, and they wind up in court. And it can be avoided. It could probably be avoided in all states, you know, I would imagine. I know it can be avoided in Florida. And it also applies, sometimes I say, well, when an individual dies, if a couple dies at the same time, they could run into the same problem. So I created an acronym for it, and I'm going to share it. You know, I don't think it'll take up the whole 23 minutes, and hopefully people have questions. And anybody who's interested in getting a copy of the acronym, when Steve asked me how to find me and stuff like that, you're more than welcome to email me, and I'll be happy to share it. It's not copyrighted. I did put a Florida disclaimer on it because it's, you know, legal advice. But so probate. So the first thing is about property. The P stands for property. Like I said, any asset known in an individual's name. So if people are unmarried, oftentimes they own assets in their own names. They have their own checking accounts, banking accounts, IRAs, whatever. They don't name beneficiaries. That will go to court. Now, you can do an estate plan for whatever dollar amount you find works for you, and a probate action will cost you some multiple of those dollars. So you really want to do everything you can to avoid it. And the cat is so glad to be here this morning. Well, I just lost Steve. Hold it a second. Okay. The cat reduced the screen. So you really want to be sure that all your property, homes, have beneficiary designations, however you do that in your state, all your bank accounts, all your IRAs, all of it. There are rules. Every state has their own rules. Some states are probate friendly. North Carolina is a probate friendly state. Florida is not a probate friendly state, as my clients have found out. So the rules are whatever they are. And if you've had a will and you've named somebody to represent you as your personal representative, whatever, that's the person who's responsible for getting the legal action started and bringing it to fruition. That role has obligations. It's what they call a fiduciary role. So who's ever in that role is supposed to do what's ever in the best interests of the estate. But there are specific rules, there are specific time frames, and probate will get delayed because who's ever appointed is not able to keep up with the rules. Bills and beneficiaries is the B. Here's the tragic part. An individual is not responsible for somebody else's bills. So Steve and Sophia are a couple. If Steve has accounts in his name only, Sophia has no legal obligation to pay those bills. Steve's estate does. And here's what happened recently. A friend took over I took over for my best friend, and my best friend had a credit card bill in the amount of $15,000, and nobody told me I didn't have to pay it. I took that money out of my IRA and paid it. And there's no way for me to get that back. So you really want to talk to somebody. Attorneys are involved most of the time. Very rarely do you not need an attorney to get a probate through. So you want to be careful about that. It takes time. Different levels of probate take different amounts of time. If you have a very small estate, under $75,000 in Florida, it can be done in not a lot of time. If it's over that, it takes generally a year, and that's just based upon the rules. And exit strategies, I really like this one. Exit strategies is do your plan. Do your plan now, have everything in place. Don't leave your family to grieve for you and be angry at you while they're doing it. So that's a brief rundown. Steve can now ask me questions. If anybody has a question, I'm happy to answer it.
Well, we got our first text from Anderson in Tampa. He wants to know what makes probate so expensive?
Well, there are court costs. There are administrative costs that come with it. What makes it so expensive is what's the expanse of the estate. If somebody passes and all they have is a home in Florida, it's expensive is a frame of reference. So I don't know what expensive would mean to Anderson or anybody else. A few $1,000s to do that, to keep the home and get it into the names of whoever it belongs to. If there are monetary assets, then you have to deal with banks and you have to get account numbers and people have to do research. If there's no will, there's additional paperwork that's involved. So it's time intensive. I only use flat fees because I don't ever want to feel that my client's being nickel and dimed, or I've spent a lot more hours than I could have imagined spending because it got complicated. To Anderson's question, I have a client now where the beneficiaries are in another country. And so getting documents from them has not been easy. Fortunately, they can all be done electronically, but they don't come back in a timely manner. And I have no way to find them. I don't have phone numbers and I don't have good email addresses. So we're working through somebody else. But that's why it would be expensive. I hope that answers the question.
A friend of mine, the reason why theirs is so expensive is there's somebody outside the family that is testing it, the bill, and it's causing a lot more legal fees because of that situation.
Right. I have one similar. I have a guy who called whose stepfather died, and this guy is sure the guy had a will. He's sure he didn't have any children, but we spent not a lot of money, depending upon your definition of a lot, but I probably spent 4 or 5 hours and $1,000 trying to find heirs because the stepson is not legally entitled if we can find people who are blood related to the person who died. So we've had to look for those, and that's expensive. So that's another reason why it gets expensive. And for the situation Steve just described, where somebody is contesting it, that goes into a whole different category of litigation, and that's retainer based. That's not even that's retainer based. There's no flat fee there because nobody can know if you're going to win or not. Yeah.
Debbie, if somebody's contesting it, does that come out of the proceeds, or do they have to pay for it themselves?
That's a great question. No, people sometimes think it comes out of the proceeds, which even if they're entitled to a share would come out of their share. But no, it comes directly out of their pocket. It comes directly out of their pocket. I had a probate, was now 2 years ago, where one of the grandchildren of the deceased didn't like her aunt. And so she hired a lawyer and contested it. I don't know what she paid for the lawyer, but whatever she paid, she can't recoup. She can't say, I spent $6,000, so the rest of you have to, contribute like $1,000 a piece. No, she had to pay the whole fee. So before you contest it, anybody can bring a probate, and it can be contested if people are, in my opinion, smart. So let's say I contest whatever. I contest my brother's will because he didn't leave me anything. If I'm smart, one of his daughters is going to call me and say, what are you doing? He didn't leave you anything. I mean, promise you anything? And they're going to talk me out of moving forward with it. But it comes out of your own pocket. It all comes out of your own pocket if you're going to contest it.
Rex in St. Pete wants to know, thank you for your show. I just found it. How does a person avoid probate?
Great question. So the exit strategies, you avoid probate by doing your estate plan. You always have something. You always have a small bank account or whatever. You do it by naming beneficiaries. You do it by being sure that everything you have has some kind of process in place so that if you pass, whoever's holding that money knows to whom it goes. So that's, estate planning can be done if it's simple with just beneficiary designations. When there are children involved, or there's substantial money, or there's a disabled person, then I always recommend a trust, because then your assets pass into the trust, and whoever you've appointed to be in charge of it distributes that. But probate can be avoided reasonably easily if somebody's willing to do the work to get it done, because I do not work with banks to set up beneficiaries. I will counsel people on, call your bank, get these set up. Most of them can be done online. So Rex, if you have any bank account and you've got a few $100s in it, you want to call your bank or go online and get a form that asks you to name your beneficiary. And you can do it online. You don't need to go to the bank. You just need to have their address, and most banks want social security numbers. And if you're in Florida and you want to call, I'd be happy to answer anything more specific.
This is
you in St. Pete? That's what you said.
Yeah, this is Martin in St. Pete also. I just found your show. I know this is a stupid question, but I want to ask it anyway. What does a trustee do?
Okay. A trustee is the one who accepts the appointment as trustee, and then gathers all your assets, whether it's bank accounts or IRAs or the house, and then follows all the directions you left in your trust for what they're supposed to do. Oh, if your direction is the person who died had 3 children, and your direction is to give all the children the right of first refusal to buy the house, meaning if any one of them wants to buy the house, they can do that. And then as the trustee figuring out, how do you value the house and how do you pay out the other 2 who aren't interested? But their biggest job, and it's a big job, is a fiduciary one, to carry out the wishes of the person who passed. So if they have people, Mark, where they don't want any of their beneficiaries to get money till a certain age. The trustee's role is to be sure that they don't get distributions until they reach those ages. Generally, there's something in there that says a trustee can distribute money for what they call HEMS: health, education, maintenance, and support. So if you've got a younger person and they're struggling and they need money to pay rent, then the trustee can distribute out of their share money to pay their rent. Trustee is also responsible if you've got somebody who's disabled and on government benefits, to be sure that that money stays separate, because that's a whole other conversation. But if you're on government benefits, you can't have more than $2,000. So the trustee's role is exact. Somebody needs to be responsible and able to deal. If you need, they can hire accountants, they can hire tax people, they can hire appraisers. The trustee has the right to hire any professional they need to further the needs of the resolution of the trust. Not sure that's clear, but the biggest thing to know is a trustee is somebody, the person who you appointed, somebody you really trust, and they have a financial fiduciary role to do the best they can in the best interests of whoever is going to get the proceeds. If it doesn't answer the question, again, call me.
Barbara in Tampa wants to know, how do you choose a power of attorney, and how do you do that without hurting feelings?
Oh, that's such a great question, Barbara. Without hurting feelings, I'm not exactly sure how you do that, especially if you're dealing with children. So Steve mentioned he had a daughter. I didn't know that before. Is she your only child, Steve?
No.
Okay. So how many do you have?
Two, and I've got two in Dallas.
Two in Dallas.
Daughter and a son.
I don't even know the way you said that. There were others elsewhere. Anyway, so you've got two children. Sometimes people are very torn. The way you choose is, who would you trust with your money? Most times people know who that is instantly. Most people know who that is instantly. Well, that's what you have to trust them. Go ahead.
But you know who you trust, but how do you do that without hurting the other person's feelings?
Well, for the most part, if it's siblings, they'll understand. But here's the thing. It's not about you protecting the feelings of your children. And I do understand why that's important. It's about you choosing the person who's going to do what you want, and you trust to do what you want. So for a power of attorney, it's in Florida, a power of attorney goes into effect as soon as you sign it. If you've got somebody who's struggling with credit issues or marital problems or substance abuse, you don't want to, because they can clean you out as soon as you give them that power.
Yeah.
They have the right to clean you out. Maybe they can't change a beneficiary, but they have access to all of your financial information. They can call your life insurance broker and find out what the face value or the death benefit is of a policy. They can call your bank after they get the documents accepted by the bank and find out what all your bank balances are. They can write checks on those accounts. So it's sitting down and giving a hard look. And an attorney can help you craft that conversation. And if you can't come up with anybody, you can choose a non-family member to fill any role. I have a colleague who's a power of attorney for several of her clients. I have another client who's power of attorney for a lot of his clients, and executor of their wills, because it keeps it out of the family. And you've got this impartial voice taking care. But the biggest thing, you really need to trust the person. And then if you need a difficult conversation, hopefully your attorney can help you craft it or bring everybody together and help explain it. But yeah, it can be a very, and And I don't recommend appointing two people to serve for the same role in that role. Because if they don't agree with each other and they both have the rights, I can clean you out today and Steve can sue me tomorrow because I cleaned out our mother's account. So not a good idea.
I want to get this text in. I know this is not about probate, but we're talking about trust. What do you say to a family member who wants to contest a will?
Go ahead. I'll find somebody who'll do it for you. I do not work with people who want to contest a will. I'm not saying there aren't good reasons to do it. It's really hard to prove. It involves court, and it's expensive. So I've only had a few people call and want to contest a will. I think I persuaded them not to because of the emotional cost to them of doing it. I know a family where one of the sisters, the parents had a trust, and one of the sisters was very unhappy with what she got. When they formed the trust, they thought everything was worth the same thing. And when the second parent died, the property had very disparate, very divergent values. And the one who got the lowest value wanted to sue, and she did. And it took 4 years to settle the trust. And the siblings don't talk to each other anymore.
Oh, how sad!
So
that is sad.
I know people who do it, but if you want to contest the trust, you really want to have a strong case. Other than you emotionally don't think it's fair, or it's the principle of the thing, which I totally get, but it's really expensive.
You know, Debbie's been with us now several years, and I remember our first conversation. She said, I want to keep people out of probate because it becomes very expensive. Now, can you imagine a lawyer who makes their living, on their time? Here's attorney Debbie Baker saying, I don't want them to have to go through probate. That is the kind of attorney I want. Debbie, how do people reach you?
Yeah, and I'm hoping somebody who heard at the beginning about probate might be interested in the acronym. But my phone number is 813-586-1332, 813-586-1332. The website is londonbakerlaw.com. Remember the law, because some people often leave it off. And the email is Deb Baker, 2 B's in the middle, Deb Baker at londonbakerlaw.com. For all of you who sent in questions, it really makes it so much more fun. And it really lets me know that I learned something.
Goes by fast, and we've seen from the YouTube numbers, there's a lot of people out there watching you, not just listening. Debbie, I don't know who's the star of the show, you or your cat.
Or Pip. Pip hears Steve's voice, and if you're watching, he comes as soon as he hears the voice. Now I don't know what he sees outside, but his tail is swishing. So he sees something outside.
Debbie will be back again with us next month. Debbie, stay warm, and we'll see you next month.
And may your daughter and son be okay, and anybody who knows people who are in the middle of the storm and rebel, do everything you can to stay safe.
You're a sweetheart. We'll see you next month.
Okay, look forward to it. Thanks.
That's attorney Debbie Baker. She is an amazing estate planning attorney. We're going to go to a break. We'll be right back.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.